Okay, welcome to today's webinar, 5 Legal Tips for Young Adult Cancer Patients. First, my name is Stephanie Fahuri, and I am the supervising attorney at the Cancer Legal Resource Center. And just so you have a little sense of who we are, the CLRC, or Cancer Legal Resource Center, is a program of the Disability Rights Legal Center. Our mission is to provide information and resources on cancer-related legal issues to cancer patients, survivors, caregivers, healthcare professionals, employers, and anyone else coping with cancer. Now, the CLRC generally does not provide direct representation of the legal advice. Instead, we focus on an education model in order to empower individuals with knowledge of their rights under the law and give referrals to other legal resources when necessary. We provide services in both English and Spanish. All of our services are confidential, and for a lot more information, you can visit our website, cancerlegalresourcecenter.org. If you have questions that are not answered in today's webinar, please feel free to contact us for direct assistance. We operate a national telephone assistance line, and the best way to get in touch with us is actually by filling out an online intake form at clrcintake.org. Alternatively, you can call us. It's a toll-free number, 866-THE-CLRC, so 866-843-2572. And we are able to provide some more detailed individual assistance and referrals. So what are cancer-related legal issues? What might someone call the CLRC about? Well, these are a few of the various issues that people with cancer frequently face, and I'll touch on a few of them in today's webinar. The CLRC exists to help you navigate some of these laws that might apply and to provide you with information and resources regarding these issues. So without further ado, let's get started with 5 legal tips for young adult cancer patients. About 70,000 young people ages 15 to 39 are diagnosed with cancer each year in the United States. And that accounts for about 5% of cancer diagnoses in the United States. And it's about 6 times the number of cancers diagnosed in children ages 0 to 14. So my goal for today is first to let you know that we exist as a resource and you can contact us with additional questions. But really, the main goal is to let you know the types of things that might come up for an adolescent or young adult who might currently have cancer or might have a history of cancer. Many people don't know what their rights are and find out when it's too late to do anything about it. I also want to encourage you to check out the educational materials that are available on our website, as well as any other webinars that we have presented, both available on our YouTube site and on our website, which might cover some of these topics in a bit more detail. So, tip number 1, you might be entitled to accommodations at school or when applying to school. It's important that students with cancer-related disabilities understand their rights and responsibilities when they're preparing for college-level courses, and beyond. While there are many protections that exist for students of all ages, students have more responsibilities at the college or graduate level to request and assist in identifying the accommodations that they might need. Many of the protections that are available for younger students, students in elementary or middle school, maybe even high school, such as free appropriate public education and the Individuals with Disabilities Education Act, FAPE and IDEA, those do not necessarily apply to college-level education. So the following information can help students with disabilities or history of disabilities prepare for and succeed in college classes. So here are a couple of the laws that might provide some protections for students with disabilities in higher education. Section 504 of the Rehabilitation Act of 1973 is a federal law designed to protect the rights of individuals with disabilities in programs and activities, such as educational programs, that receive federal financial assistance from the U.S. Department of Education. Recipients of this federal financial assistance include public school districts, institutions of higher education, both public and private, vocational schools, and other state and local educational agencies. On the other hand, the Americans with Disabilities Act also prohibits discrimination against students with disabilities at the college level. Title II of the ADA covers state-funded schools such as universities, community colleges, and vocational schools. And then Title III of the ADA covers privately funded colleges, vocational schools, and private entities that offer certain educational exams and/or courses related to occupational certification. Section 504 only applies to schools that receive federal financial assistance. Private schools that do not receive government funds are only covered by Title III of the ADA. As a result, these institutions may be more limited in the types of accommodations that they may be able to provide depending on their available resources. But regardless of their limitations, they're still required to accommodate students with disabilities. So, depending on the type of school, college, university that you attend, it's possible that either 504 or the ADA would apply, or possibly both. So in order to be protected by one of these laws, a student generally has to be disabled, according to the law's definition, which we'll go into, or have a record of the disability, or be regarded as having a disability. So this doesn't only apply to the diagnosis or illness itself, but the side effects of treatment can also potentially be considered disabling. Cancer can be a disability under the ADA, but sometimes it's looked at on a case-by-case basis. So what is a disability under these laws? There are three parts to the definition. First, you have to have a physical or mental impairment, and it has to limit a major life activity, and the limitation has to be substantial. Physical or mental impairments should generally be expected to last more than 6 months, but some schools might still accommodate temporary impairments. And some examples of major life activities are walking, talking, breathing, activities of daily living. And then whether or not something is considered a substantial limitation will often depend on the nature and severity, the expected or actual duration, and the impact of the disability on your life. So if you wake up one morning and you have a migraine, and it's an isolated incident, it's not expected to last all that long, it might be severe, but because the expected or actual duration of that particular migraine might only be that day or maybe 2 days, most likely that's not going to be considered a substantial limitation. If, on the other hand, you have some sort of physical or mental impairment, such as chemo brain, or attention deficit disorder, or some other sort of long-term impairment, that might be looked at as something that is substantial because it's expected to last a very long time, it's affecting a major life activity, and it's an impairment. So during the admissions process, before you even start at any of your schools, you might potentially be entitled to accommodations. So students with documented disabilities may apply for accommodations when they take college board exams, including the PSAT, SAT, SAT subject test, or AP advanced placement exams. Both laws ensure that students with disabilities may not be denied admission to school on the basis of their disability. A college or university may not use discriminatory methods to screen out or limit the number of students with disabilities that may apply or be admitted. Once a student has been admitted, a school may ask whether a student has a disability on a confidential basis to determine if an accommodation may be needed. So you might be able to get accommodations on exams. Schools can't ask about disabilities, and you're not required to disclose your disability unless you're going to be asking for an accommodation. Additionally, during the admissions process, you might be interested in possibly explaining some performance issues, or if you had to take a year off of high school, for example, or if it took longer for you to complete a certain course than maybe your peers, and the reason was because you were going through cancer treatment or you had some other issue. During the admissions process is when you might have the opportunity to explain how your disability has affected performance. You can write about it in your personal statement. You can add addenda to your applications. This isn't required, but some people do choose to disclose in that way. Now, once you start school, you might want to know how the ADA and Section 504 protect you. Generally, colleges and universities are required to make reasonable accommodations for students with disabilities. These types of accommodations may also be called academic adjustments. The accommodations may include modifications in the school's practices, policies, and procedures, or provision of auxiliary aids and services. An appropriate accommodation is determined through an interactive process based on a student's disability and individual needs. So it's not a one-size-fits-all. They really do look at what would be most helpful for you in your situation. A school is not required to make any adjustments that would fundamentally alter the nature of a service, program, activity, or would cause an undue financial or administrative burden. A school is also not required to waive or lower essential requirements, nor required to provide accommodations to students who do not disclose that they have a disability. So you obviously have to let them know that you have a disability in order to get an accommodation. So some types of reasonable accommodations that a person with cancer or a person with a history of cancer might need could be extra time on exams, or note-taker services, or possibly additional excused absences. Some professors are pretty strict about attendance. If something comes up and you know that you're going to need to attend some extra doctor's appointments, or are more sick in a given semester than you were in a previous semester, you might want to let them know that you're going to need accommodations, so that it doesn't turn out that, oops, you forgot to let them know you have too many unexcused absences, and then you fail the course. So if you've been accepted into a college or graduate program and you have a disability that needs an accommodation, you might be wondering about how to go about requesting the accommodation. Most post-secondary educational institutions have an office or a designated individual, such as a disability services coordinator or access coordinator, who is responsible for coordinating accommodations for students with disabilities. Usually you can find this information on your school's website. If you're really struggling, you can always contact the Dean of Academic Services, the Dean of Student Services, or even the admissions office, and they could probably tell you who's responsible for ADA accommodations. And again, the information that is shared about your disability has to be kept confidential. They can potentially require medical documentation, but the information is only shared on a need-to-know basis. So in the previous example I gave, they wouldn't necessarily need to tell all of your professors and all of your teaching assistants or your classmates or anything like that about your disability. But if you're having issues with one particular course and you know that the attendance policy, for example, in that one course is more stringent than you're going to be able to handle, then potentially the disability services coordinator would coordinate that with that particular professor. So I sort of alluded to this already, but you might be wondering, okay, so now I know the process for requesting accommodations. I know I'm going to need an accommodation. When do I ask for it? Well, the most important thing to do is to ask for the accommodation before your performance is affected. This will enable you to, you and the school, to plan accordingly. Some accommodations may require more time to arrange, and it is generally more costly and more difficult for a school to secure accommodations at short notice. Waiting too long to ask for an accommodation might also mean that your disability affects your performance on a test or project, and poor performance could ultimately result in your receiving a poor grade or having to repeat a class. And usually if you have to repeat a class, that means you also have to pay the tuition again. If the need for an accommodation arises unexpectedly once you've started a program, or if your need for accommodations changes, you can contact the school's disability service office as soon as possible. So, we have talked to students who've called our telephone assistance line who did not ask for accommodations before their performance was affected. And it's much harder to get a school to retroactively grant the accommodation once you've failed the class or once you've been forced to take an incomplete. And so realistically, the best option, as soon as you know about your need for an accommodation, it's best to tell the professor or tell the disability services office, because you don't want to have to be caught in a situation where you're going to have to repeat a class, pay more for tuition, especially if it's something as simple as potentially, making up the work afterwards or attending. There's a number of different ways to accommodate attendance issues or needing extra time on exams. So make sure that you ask for accommodations before your performance is affected. Okay, moving on to tip number 2. So let's say you've already attended college or graduate school, and now you are diagnosed with cancer and unable to work. It's possible that you might be able to get your student loans forgiven. Student loans currently account for over $1 trillion in debt in America. And while some students are able to make it through college or graduate school without having to take out loans, most students do need to take out some loans in order to afford to further their education. It's often difficult enough to pay back student loans even if you're healthy and have a job. And so an unexpected cancer diagnosis can make it even more difficult to repay some of these loans. There is a program that can potentially help some people. So the first thing to think about if you're unable to pay back your student loans is to look at what some of the less dramatic options. So you might be able to get something called a deferment or a forbearance if it seems like maybe the issue is temporary. So a deferment, if you're facing a temporary loss of wages or funds, you might want to consider this option. A deferment is a period where repayment of the principal balance of your loan is temporarily delayed. During a deferment, you do not need to make payments, and depending on the type of loan you have, the federal government might pay the interest on your loans during a deferment. Alternatively, if you can't make your scheduled loan payments and you don't qualify for a deferment, because the loan servicer is the one that makes the decision as to whether or not to give you a deferment, and there might be limitations on how many deferments you could get. A different option is called a forbearance. With a forbearance, you might be able to stop making payments or reduce your monthly payment for up to 12 months. Interest will continue to accrue on your subsidized and unsubsidized loans. And so to request a forbearance, you can contact your loan servicer. They are usually able to make the decision as to whether or not to grant the forbearance. They have that right to choose whether or not to grant it. There are a few situations where there's a mandatory, they're required to give you a forbearance. But if the issue is really that you are having a financial hardship or illness, that's really at their discretion whether or not to grant it. So what if you're still not able to pay back your student loans? What if you are facing a situation where you have very advanced cancer and are disabled? Well, potentially there is a program called Total and Permanent Disability Discharge that might be able to help. If you borrowed certain types of federal loans to attend college or graduate school, and you have a total and permanent disability, you may qualify to have your loans forgiven or discharged, so you don't have to pay them back. The federal government has a program called Total and Permanent Disability Discharge, TPD, and it applies to only very specific types of loans. So these are direct loans, federal family education loans, and then Perkins loans. And it also applies to individuals who had to complete a teach grant service obligation. So TPD discharge only applies to federal loans that you've borrowed for college. Private student loans borrowed from a bank or other financial institution are not eligible for the TPD discharge program. Private loans are not subsidized or regulated by the federal government and do not have the same types of discharge, deferment, or forbearance options that are available for federal loans. If you have a private loan and you're unable to pay it, it is best to contact your private lender and find out if you can negotiate some of the debt or come up with an alternative repayment plan. So if you're thinking about TPD, Total and Permanent Disability Discharge, you'll have to fill out an application and provide the U.S. Department of Education with some information to show that you are totally and permanently disabled. If you are receiving Social Security benefits or veteran benefits or long-term disability benefits, there's a few different ways to show them that you are totally and permanently disabled. And once they have reviewed your application, if they approve you, your loans are discharged or, essentially forgiven. However, you might face a 3-year monitoring period where they'll check back in to see whether or not you continue to be disabled. So, make sure that you are aware of the monitoring period and that you're able to provide information about your permanent disability or your disability that's expected to last at least 5 years or end in death if you're thinking about applying for this. Now, once your loans are completely discharged, the amount of debt that is discharged does get reported as taxable income for the year the loans are forgiven. And that's in addition to any other taxable income you may have. So while it sounds like a really great thing to have all of your student loans potentially forgiven, it is important to keep in mind that anything over $600 is taxable income. Now, NELNET, which is the organization that handles the disability discharge, they send a form 1099-C that you'd have to fill out and include when you file your taxes. Now, if you are unable to pay the IRS the amount owed from your discharged loans, it may be best to contact the IRS and ask if they can negotiate a repayment plan with you. Although they are not required to negotiate a payment plan, there might be different options available for individuals who cannot pay the full amount owed after a TPD discharge. There is an insolvency exception that applies to taxpayers who receive a TPD discharge. So a taxpayer is considered insolvent when the amount of taxes that he or she is responsible for is much greater than the amount of assets that the taxpayer has. As a result, the discharge debt is not considered income for the taxpayer, and he or she does not have to pay taxes on that amount. To apply for the insolvency exception, you have to fill out another IRS form, which is 982. If you're thinking about applying for the total and permanent disability discharge, it's most likely in your best interest to talk to an accountant, or possibly if you're thinking that you might be considered insolvent and unable to pay the taxes owed on the money that's forgiven, you might want to talk to a lawyer at your local legal aid organization to see if they can provide some assistance or clarity. And you can always call the CLRC and we can try to put you in touch with someone. So here's a couple of resources if you are facing issues with your student loans. Disabilitydischarge.com is where you would go to potentially fill out the application form for TPD. And if you have other questions about student loans, studentloanborrowerassistance.org is a great resource. Okay, so tip number 3, be proactive in your healthcare. Ask your doctor about clinical trials and/or fertility preservation. It is your responsibility to understand your health coverage. So for young adults who either have cancer or who have a history of cancer, you're put in a sort of a unique spot. Many cancer therapies are, aimed for maybe older people, or there are potentially older people that are more frequently using certain cancer therapies. You're not quite pediatric patients anymore, so you're sort of in your own category here. And depending on your age, you might still be on your parents' health insurance plan. That means that you might maybe have never had to investigate or learn more about your health coverage. And even if you're on your own health insurance plan, if this is the first time that you've been sick, you might not be super familiar with your health insurance coverage anyway. And that, in fact, as a young person myself, most of my friends my age know very little about their insurance coverage or about how insurance coverage works in general, unless they've been sick. So in case no one has ever mentioned this before, it is very important for you to learn as much as you can about your health coverage. Get a copy of your policy and read it. It's almost always available online if your health plan has an online portal. Your insurance company is also required to give you a copy of your health plan if you request it. And if you don't have insurance, call the CLRC and we can talk to you about what some of your potential options might be. If you're on Medicaid or if you're on Medicare because you've been receiving SSDI for a while, you might be able to request a case manager through your county, and Medicare has hotlines in every state that you can call for questions. So in addition to learning about the basics of your health coverage, one important option to consider when thinking about your treatment is clinical trials. Although there has been a lot of progress with respect to pediatric cancers as a result of a large percentage, actually more than 60%, of pediatric cancer patients participating in clinical trials, the same has not been true for cancers affecting adolescents and young adults. Relatively few adolescents and young adults participate in clinical trials, and one of the main reasons is that even at major cancer centers, there are few clinical trials available to this age group. Clinical trials are research studies in which people volunteer to test new treatments, drugs, or procedures. There are many potential benefits, but there are also many possible risks. So if you are interested in potentially, helping the cause, contributing to research and science, and also potentially if you have a type of cancer that maybe doesn't have a lot of available treatments, you might want to check with your doctor to see whether there are any clinical trials that might be available to you, because there's certainly a need for more people in this age group to participate. So after the Affordable Care Act was passed, and now post-2014, there are some changes to health insurance with respect to clinical trials and what has to be covered. Depending on what state you live in, there might have already been some protections available to you. But now, under the Affordable Care Act, for newer plans, health insurance has to cover the routine costs of approved trials. And they cannot discriminate against an insured person for participating in a clinical trial. So the trial should cover anything that's not part of your normal insurance's standard of care. The clinical trial would cover, whatever drug is being tested, certain things that are done just for data collection. But, if you were going to have 2 MRIs over the course of a year anyway, and the clinical trial wants you to have 6, your insurance company, if they were already going to cover 2, they would still have to cover those 2 MRIs, and then the trial would most likely cover the other 4. So that's just in case you're curious about insurance coverage for clinical trials. So where do you find clinical trials information? If you're looking to join a trial, the first step really is to talk to your doctor, because new clinical trials are created constantly. Many people also look in other places to find research studies that they may be interested in joining. If you haven't looked at clinicaltrials.gov, I would suggest taking a few minutes to search around. Additionally, the National Cancer Institute has a number of cancer-specific trials available. The American Cancer Society has a clinical trial matching service. So a lot of these are really good options if you're starting to look at possible trials that you might be eligible for. Now, the other thing that you need to keep in mind is that it's not something that you can just sign up for, and you might even look on one of these websites and find a trial that it seems like you're qualified for, but then you go in person and it turns out you're not actually eligible. Unfortunately, that's not something that you can necessarily appeal. It's not the same as, if your insurance company denies you coverage for something. Every trial has its own protocol. They have their own rules. So, depending on the types of treatments you've had in the past, or depending on your age, or even your ethnicity sometimes, there might be various reasons why you are or are not eligible to be part of a given trial. So again, talk to your doctor. It's a great place to start. Now, the other thing that I want to mention that seems to sort of fly under the radar here a bit is the idea of fertility preservation. So if you are in a position right now where you are maybe about to start treatment, or you're talking about your various treatment options, and you are at an age where you could potentially have children, you might want to talk about fertility preservation with your doctor. The estimated number of cancer survivors of reproductive age in the United States is now approaching 500,000. Although cancer treatments have evolved to cause fewer harmful side effects in these patients, radiation therapy and many chemotherapy agents can still damage fertility. The most frequent cause of impaired fertility in male cancer survivors is chemotherapy, or radiation-induced damage to sperm. The fertility of female survivors may be impaired by any treatment that damages immature eggs, affects the body's hormonal balance, or injures the reproductive organs. There are a number of different options depending on, your age, your development status, whether or not you potentially have a partner. So IVF, in vitro fertilization, is the most common assisted reproductive technology where your eggs could be preserved. There's embryo freezing, and the cost to have IVF and freeze embryos is about $15,000 to $18,000, and that actually might even be an outdated number. Another option is potentially egg freezing, which can still be extremely expensive. And usually insurance doesn't cover IVF or egg freezing. Fertility preservation is usually a lot easier and cheaper for men, But depending on your age and again your where you are in the development scheme of things will really make a difference as to what the options are. Now, some of these things, as I mentioned, are extremely expensive, but there are resources available. So options for preserving cancer patients' ability to have biological children do depend on many factors, and it really shouldn't have to also depend on money. Most options, whether established or experimental, are costly and unlikely to be covered by health insurance. Most of these options have to be undertaken before or during cancer treatment. Patients who have just received a cancer diagnosis usually have a very brief window of time in which to decide whether to pursue fertility preservation, and if so, to determine which procedure is most appropriate for their circumstances. So if you want to know more about oncofertility or fertility preservation, you can contact any of these organizations. Some of them provide financial assistance, some of them just provide more information and resources, but please feel free to check those out. Okay, tip number 4, don't just talk about your wishes, document them. Many young adults fail to plan ahead because they either have very little by way of assets or property, or they assume that their parents will take care of everything for them. However, everyone should have a plan in place regardless of current health and regardless of how much or how little property they own. Now, obviously, there might be certain requirements in order to create a will or any other sorts of advanced planning documents. If you're under 18, you might not actually legally have the right to do so, or legally have the ability to do so. But, if you're over 18, to ensure your wishes are upheld and to make decisions easier on loved ones, make sure that these documents are created before they're needed. And honestly, even if you are already a cancer survivor, you're in remission, most of this is in your past, it's a good idea for anyone to have these advanced planning documents. And even if you're comfortable talking about death, you might not realize how important it is to have your wishes written down in official documents like advanced health directives, powers of attorney, wills, and/or trusts. Make sure you have a financial power of attorney and other documents prepared. Serious issues can present themselves if a person becomes incapacitated or dies without any of these official documents. There are many free forms available online, and the CLRC can help guide you so you know what you might need. So there's 2 main parts to advanced planning. The people and property part of it, so like wills and trusts, powers of attorney for finances, and then the health part of it, so advanced directives, powers of attorney for health, instructions, etc. So generally speaking, you're probably going to want to designate someone to manage your property and finances in a power of attorney if you should become unable to do so, and you want to name beneficiaries or recipients of your property in a will or trust. For the second part about your health care, you're probably going to want to document your wishes for care in an advanced health care directive for health care, and you should name someone to make medical decisions for you if you become unable to make decisions for yourself. So what happens if you don't set up a will? If you die without a will, it's called dying intestate. State law then determines where a person's estate will go. And I just want to flag one thing. When we talk about estates and estate planning, I'm not talking about, Downton Abbey, where you have to own, a huge house with rolling hills and you have servants and butlers. I think the term estate, we tend to think about it in those terms. But literally anything you own can be considered part of your estate. If the only thing that you own is the shirt on your back, that's your estate. And maybe some people don't really care or they trust their parents to make those decisions for them. But maybe your parents aren't around anymore. Maybe you actually really care about who gets that shirt on your back and you really want your best friend to get it because your best friend was there with you when you bought it. If that stuff is important to you, you might want to create a will to make that clear. You know, the other thing is that for a lot of young adults who maybe don't have families of their own yet, but you have a pet, maybe you have a cat or a dog, that's part of your estate too. And so if you want to make sure that, you know, if something happens to you, you know exactly what's going to happen to your beloved pet, you might want to set up a will or a trust. Without a will or a trust, you really have no say in who gets what. Even if a person doesn't own much by way of property and doesn't really care about having a will in place, people often forget that they actually do have some things like their pets or like, you know, that one special shirt, that they actually do care who gets it. So, you know, when we're talking about health decisions, I'll move on to talking about some of the tools about planning medical treatment or instructions for foregoing treatment at the end of life or when someone is unable to make decisions for themselves. So in some states like California, there are 4 different parts to an advanced healthcare directive. You might have actually also heard the term living will. In some states, a living will is a separate document. In other states, the living will is part of the Advanced Healthcare Directive. So you can go to caringinfo.org and get more information about. You can download free forms for your state. You can contact us at the CLRC and we'll, you know, share with you information about what the requirements are in your state. But just so you have a sense of, you know, what goes into an Advanced Healthcare Directive. First, there's the power of attorney or the agent. It's where you name someone to make decisions for you if you become unable to make decisions for yourself. And so, you know, a lot of people just sort of assume, oh, it's fine, my parents will make decisions for me if I'm not able to. But if you think about it, you know, not all of us believe the same things that our parents do. Not all of us want to have to put our parents in that position to make some of those really hard choices. And so maybe there's someone else that you trust more or someone else that you think better aligns with your values. Maybe a sibling would be a better person to choose to be your agent, or your boyfriend or girlfriend or your best friend. It can be really hard on parents to make some of those choices, especially if you want to forego certain types of life-saving treatment. So really think about who you want to name as your power of attorney or your agent and have a conversation with that person. Make sure that they know and make sure that they're okay with the idea of making those choices for you. Another part of an advanced healthcare directive, as I mentioned, could be the living will or the instructions. This is where you get to actually list out some of the things that you do or do not want. So, you know, in a situation where, let's say you're in a horrible car accident or you have a surgery and there are complications and you know, maybe you're in a coma or something, if there are certain things that you can anticipate that you know you don't want, you can put that in the living will or the instructions. For things that come up that maybe aren't explicit in your instructions, that's where your agent or power of attorney would come in to help make some of those choices. Now, another section might potentially be organ donation. That's also usually run through the DMV, so you can, you know, put information in there or not about whether you want organs donated. And then there's a section for putting in information about your physician. Now, if you have any of these documents, it's a good idea to tell people that you trust where they're located. You don't want to put it in a safe deposit box, although I don't know any young people that actually have a safe deposit box. I barely know any older people that have safe deposit boxes anymore. So, you know, it's just a good idea to make sure that people are aware that A, the documents exist, and B, where they're located so that they can get them, you know, at the appropriate time without too much hassle. Okay, now moving on to our final legal tip here for young adults with cancer or a history of cancer. You don't have to tell a new employer about your cancer history. We get calls all the time from people who say, okay, well, what am I required to disclose to my new employer? Or I'm going to a job interview, do I have to tell my employer that I left my last job because I had cancer, or that I had cancer 10 years ago, or anything like that? Maybe you haven't had much experience in the workforce yet. Maybe you've already started your career and you have had to take time off. But, this question comes up very, very frequently. What can I keep confidential? What should I tell my new employer? I mean, the basic answer to that is that you never need to disclose to your employer that you have a medical condition or that you had a history of a medical condition unless you are asking for a reasonable accommodation or some sort of medical leave. However, if an employee chooses to reveal that he or she has cancer or had cancer or another disability, the employer can then ask the applicant if he or she will need an accommodation. And you do not have to disclose that you've taken any medical leave in the past. So we talked a bit about reasonable accommodations in higher education, but there's a similar idea here in the workplace. So the Americans with Disabilities Act also applies in employment. And so just like in the education context, the ADA allows for people with disabilities to get accommodations in the workplace that allow them to do their job. So reasonable accommodations in the workplace are changes or adjustments in the work environment that enables an individual with a disability to enjoy equal benefit and employment opportunity. Employers are required to make reasonable accommodations unless it causes them an undue hardship. So, for example, let's say you apply for a new job, you're working, and then you find out that you are, again, maybe just like in the education context, it turns out you're going to need to start going to more doctor's appointments. And maybe your new employer has a pretty strict, time clock, punching in policy that you have to punch in by a certain hour, you have to show up at a very specific time every day. A change or adjustment in the work environment, a possible reasonable accommodation in that situation might be that you are granted additional time off or more flexibility with your schedule. Maybe instead of coming in by 9 every day, you're able to come in at 11 and work 2 hours later because you have a morning doctor's appointment. Or maybe your condition has made it so that you are very fatigued and you're working as a cashier, and instead of having to be on your feet all day long, you might want to ask for a stool to sit on as a reasonable accommodation. That's something that probably would not cause your employer an undue hardship. Stools are not very expensive. So there are some good employment resources available that provide practical information for people who are either entering the workforce for the first time after a cancer diagnosis or who need assistance with accommodations. So Cancer and Careers, and then also the Job Accommodation Network. And we have a couple other webinars available on our YouTube page, but if you have questions about any of the 5 legal tips that I have shared with you today, or if you have questions that come up about any other cancer-related legal question, please feel free to check out our website, cancerlegalresourcecenter.org. You can call us at 866-CLRC. And thank you so much for joining us.